going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chunky! I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Happy Sunday. Hopefully everyone's well. Hope you guys had a great Saturday. All right, I got a good one. Judge King. This is the end of a hearing, the end of an exam. Now, I only have the end of it because this is where the guy goes to jail. If you want to watch the entire part or the entire hearing, I will have the link in the description. It was the last case of his docket on the day that I have the link. So just skip to the end. You can watch the entire thing if you want to. All right. Before I hit that play button, you already know what to do. Hit the like and subscribe to your jump kick backflips. Let's go.
Phone dump information. Okay, so that's going to necessitate us getting another date. How much time do you need, counsel?
Unfortunately, I'm out next week.
It's not going to be good for your client because your client may not be out next week.
Yeah, a little bit of foreshadowing. You're out next week? Well, that means your client's going to sit in jail a little bit longer.
Thursday. Does that work for you, Mr. Fedora? I'm not sure if it works for the court. Because of this.
It's fine for the life staff to be
1:30?
1:30.
Mr. King? It works for the counsel. All right. Now let's talk about bond. I want to know why the defendant is not able to get the settlement in this order.
So we actually called, Ms. Montez called the court last week because, change my words here. The court, when I raised the issue of Mr. Moore being incarcerated as he waited to tether, the court said they could fashion a way that wouldn't have to happen. So the defense counsel took that to mean that the court would get back to us. Mr. Moore did contact us and asked us, because the court said that something should happen by Friday of that week. He asked us what the status of everything was. I asked Ms. Montez to call the court to see what the circumstances were for fashioning, because I had no idea. And we were told, I think, to draft the order.
I told the defendant to present himself by Friday to have a tether and to await direction from them. Because if they were not able to provide him a tether at that time, then for them to give him a time to get the tether.
I have no reason to think that the court didn't make that note. I'm submitting to this court as an officer of the court. That was not the memory of either Ms. Montez or myself, because we went through this with Mr. Moore countless times. And I made it clear to him that I didn't know what the court was talking about with regards to fashioning some conditions.
What I was trying to do was avoid him sitting in jail waiting on a tether. Because sometimes it takes 3 to 4 days. So I was giving him the benefit of the doubt to present himself in person, so he wouldn't have to spend that time in jail waiting on the tether. And I'm being told now that that didn't happen.
I will follow my own sword. I told him that not to. I said that wasn't my understanding of the court's order.
And
Told
I,
him not to go to the tether office? Why would you tell him that?
because I wish I had the transcript. I believe that the court.
Oh, I've got the transcripts. Well, not the transcripts, but I've got the previous hearing. Let's hear it. Let's see how exactly this went down.
No, we paint a very different picture than what it appears like on paper. On paper, these charges not only are they disturbing, but they are just charges, they're just allegations at this time. The purpose of the bond is not for punishment. The court does recognize that. However, I cannot ignore your client's extensive criminal history. In fact, these charges, habitual fourth offense notice, mandatory 25-year sentence. These charges were first degree murder, premeditated, as well as assault on a pregnant individual intentionally causing miscarriage or stillbirth, and felon in possession of firearm. This court hasn't heard a shred of evidence as of yet. I recognize that those charges in his criminal history do give me pause. He's quite frankly lucky to be out and not on a remand status. All that being said, I am inclined to put a tether on, but as I indicated before, I'm not going to lock him up at this point. I'm going to give him a date certain to go and have the tether placed on him. And I will make provisions for him to continue to work. There'll be house arrest, but he'll be able to go to work only, work in court only. I don't think he's a flight risk, however, I think he may be, based on his criminal history, he may be a danger to the community.
All right, just real quick. I already know what's going through your guys' head. He is out on a $200,000 bond. Now, during arraignment, when the magistrate gave him that bond, the arguments were said, and the defense strongly believes that he didn't do this, and they at least won that day where he got a $200,000 bond instead of instant remand. He's charged with some pretty heinous things. And he is innocent until proven guilty. He paid the $200,000. Now, the prosecuting office or the prosecutor is still trying to remand him, even though he paid the $200,000. There's a lot that went into this. It's kind of wild, in my opinion. I don't know why he's out with those charges, but he paid the $200,000, and the prosecutor is still trying to lock him up. So Judge King's just giving him a tether. But let's see. Now he's about to give the wording, and I want to know what you guys think. Does he say you need to report by Friday? We'll find out.
So figure out how I'm going to contact the tethering agent and have them contact you when he's coming and have the tether placed on. I want to get that done by this week.
All right, there you go. You need to contact the tether agency. I want that put on this week. Did he say by Friday? No. He said this week, though. That's what he said.
Myself, my understanding, my memory, my recollection of what happened was that I raised the issue and the court said they could fashion something that could result in that, and that you hear from the court by Friday.
Yeah, that's what I did, and allowed him to be out and to present himself.
Okay. Well, if I may. Mr. Moore has presented himself for the homicide charge. Ms. Montez took him to DDC herself at 3 o'clock in the morning when we knew this warrant was out. Opposing counsel gave us 24 hours to have him turn himself in, and he did. He knew this charge was coming down because it initially started as a CCW charge, and we were notified and signed a order, protective order, to get the homicide discovered. Mr. Moore was told that night that there was a homicide charge coming. He did not flee.
I've seen this movie before. These are the exact same arguments you made last time.
I'm just asking to do with the change, because I think it's not fault.
Sir, you didn't understand?
Stand up, sir.
You didn't understand what I said when I told you to present yourself by Friday?
Yeah,
I don't know how much clearer I can be.
no, I was thinking that he was gonna refer to him, he was gonna relate to me, I ain't never been to this, I don't know. Give me just one more
This
check.
defendant stands before this court charged with first degree murder premeditated, and he's charged as a habitual fool. I can't think of another circumstance or situation where a defendant would be out on bond. On any bond. And per the Constitution, these are one of those limited circumstances where I can deny bond, and that's exactly what we can revisit bond again after the preliminary examination is continued.
Given what the court just heard, what every judge before this court has heard, in the facts of this case, this court thinks that this type of case warrants someone being remanded right now.
I have a dead woman, I'm yet to hear all the circumstances surrounding it, I have a dead pregnant woman at that. I don't know what's going on, but we want to err on the side of caution, and that's for the protection of the community.
Darn, can I go to the teller office today? Like, please,
No, sir. I gave you an opportunity, I gave you more than one.
I would just ask the court to put the transcript. I really think the court can do this.
Sure.
Is there a way I can get the transcript today?
Try down.
If I get the transcript today, can we believe it? I really think the court can do it. 'Cause
I know what I said, counsel. I take the transcript.
I think I know what you said too. I'm respect. I take copious notes. I'm sitting next to my client. Liberty is something I take seriously.
Not only did I say it, I indicated it in the file as well.
I have no doubt that you wrote it down. That's what I'm saying. I have no doubt in my mind that you wrote it down.
Your exhibit.
Thank you.
That is just not the recollection of myself or Ms. Montes. And it's not even something the prosecution asked for.
Is there another exhibit? Was it just one? All right, thank you.
All right, that's all I got. Hope you guys have a great day. I will be going live tonight and hope to see you guys tonight. But until the next time I see you,